had another commitment, so I apologize for that. But what I've done is I've geared a presentation that I've somewhat dusted off, and my intent was to give this to the Water Development Commission as well, and to kind of update them on some of the things that you guys probably already know, but I'll go ahead and go through it. I was going to start with some of the legislation that was passed that impacts our agency. And the first one I'll talk about is our budget. Legislature was kind enough to reinstate the assistant state engineer. And we have not started advertising for that yet. I just have not had time to work on that yet. And that appropriation is available in July at the start of the new biennium. And then the other position was a position in the Green River Basin to help us with the Colorado River. And that position, the duties of that position, or anticipated duties of that position, have evolved since it was first introduced about a year ago, probably, from now when that concept came up to what it is ultimately now. And we're meeting internally next week to develop kind of what we think that position should be. And I say that because we're including several of my divisions, maybe all of my divisions, in trying to craft what that position is and how best, what do we need in the Colorado River Basin, the Green River Basin, to help us with what's going on over there. And the way I view it right now is it's going to be probably more of a technical type of a person that can help us with some of the modeling, understands modeling, hydrology, as well as consumptive use, how we get that kind of heavy on the data side, and then the manipulation of that data to kind of help us out. So that will be the topic that I take to my meeting next week as my vision. And then we'll let our superintendent and our other division heads kind of inform what that'll be. And then hopefully within the next couple of weeks, we'll have an offering out for people to apply. So that's where we stand on those two positions. The other legislation, the first one I'll talk about was House Bill 2. This was the disposition of water rights. We think this was a really good bill. Representative Simpson ran that through for the most part, but it deals with essentially orphaned water rights, in particular in areas where subdivision occurs, and the subdivision occurs where water rights were allotted. And how do we handle that? So that the main focus was not to get rid of our old senior water rights and let them go away. And so this bill allows 4 methods of disposing or changing or moving those water rights. And it's a topic of your guys' interim topic as well on the assessments when those occur, when that situation occurs. So that was one bill. House Bill 4, this was water rights for livestock on federal lands. Basically what this bill did is, it seems simple. It requires that when a federal agency applies for a water right on an allotment parcel, that they need to have the permittee on that. Basically helps ensure that the owner, whether it be the Forest Service, BLM, the federal agency, can't just pull that water right out without impact that permittee. House Bill 36, groundwater control areas. This basically said that in contested case hearings conducted under this section, the applicant or petitioner shall bear the burden of proof. So it shifted the burden of proof to the person making the application, as opposed to one filing for or claiming an injury. I'll give you a quick update on some of the river basins. The North Platte Basin, as you guys all know, not a great year for water in Wyoming. So in March, under the process defined by the North Platte Decree, the Bureau of Reclamation makes a forecast for the available water. And anytime that forecast is not above the trigger point of 1.1 million acre feet of supply, then a call is essentially automatic, or at least that call is sent to my office for our validation and to warrant a call. And so that occurs starting in February, and February forecast was above the 1.1. The March forecast came in very slightly below the 1.1, like thousands of acre feet out of 1.1 million. So we analyzed that and we verified it, but we did not warrant it. We felt that, or we found that one of the numbers used in our calculation was the wrong number. And then the other thing that we evaluated was our restriction on LaPrelle Dam and what amount of water that restriction would provide to the system water. And with those two corrections, that put us over the 1.1 million. So in March, we did not warrant the call. And then April came, and again, the hydrology, the forecast was worse. So that put us below the 1.1. We did validate that call. And so anything at that time of the year, that call, the calling right is the Guernsey Reservoir, which is a 1923 right. So we called off all post 1923 rights in the basin. And now we are into March, and we just received their forecast. Again, it is below the 1.1 million. And so it's called an allocation year, but the parameters switch based through the decree. So rather than calling rights off, we are allowed up to 6,600 CFS of diversions in every 2-week period. And historically, we have not exceeded that. So really what that means very generally is that it's not a huge impact to our water users for the remainder of the summer. Chris, am I saying anything wrong? Okay. I want to make sure that I'm understanding correctly. So that's where we are in the North Platte. I'll shift over to the Yellowstone Basin. In April, we received a call from Montana to fill Tongue River Reservoir. And that has a priority date of 1950. And so that means that any post 1950 water right in Wyoming is called off. The call from Montana did allow us to continue to store post 1950 storage rights in the basin. What that means though is we have to, as soon as the call started, which was April 1, we have to account for all of the storage that it accrues post April 1st of a 1950 water right. The reason we have to do that then is if Tongue River Reservoir does not fill, then any of that post 1950 stored water that occurred after April 1st would have to be released to satisfy that call. And then I believe it was Monday of this week, that call was lifted. So in that time between April 1st and May 5th, there were some diversions that would like to have turned on in that time. They weren't allowed to. We tagged all the head gates and did not allow them. But as of May 5th, Monday, I issued a press release and notification to our hydrographers that the call is lifted and those diversions can turn on. And the amount of water that we were accounting for, that they can be used however they choose to use that now. So that is not subject to the call anymore. I will say that Montana can still, and they reserve the right to make a call in the future if they believe the Tongue River will not fill. But all the information we see today, both states believe that it will fill. The hydrology improved almost immediately after they made the call. We got some significant precipitation events in the basin and really improved the hydrology, which led to them lifting the call. So we're in better shape in that. I'll go to the Snake River. We are hearing the potential that both Jackson Lake and Palisades could be, those two reservoirs could be fully used this year, meaning all the water being drained and used. I will point out that Jackson Lake Reservoir, a significant portion of the volume of that is actual lake, and then they built the reservoir portion on top of the lake. So there will still be water in Jackson Lake, but it will not be the reservoir. It may not be the reservoir portion, so they may not be able to release water later in the season. They may use all of that. That could change depending on the hydrology, but that was what we had heard as of a month and a half ago, I believe. Switching to the Colorado River, a lot of work going on with that. I think you heard a lot of discussion on that yesterday. We did do some releases through the drought response operation agreement. What that means is the Bureau of Reclamation, we made recommendations to the Bureau of Reclamation. They accepted the recommendations, and they are going to release 500,000 acre feet out of Flaming Gorge Reservoir, starting in May. When did that start? May 5th through the beginning of April of next year. That 500,000 will be released. As part of that, the 7 basins, the upper division and the lower division, also agreed to a proposal from the lower basin to withhold 480,000 acre feet of release from Lake Powell to Lake Mead. So really what the attempt is to prop up the elevation in Lake Powell to help with maintain the hydropower pool, as well as protect the infrastructure in Lake Powell. This is a historic low elevation in Lake Powell, and there's some uncertainty, or no tests have been made on how the plumbing of that reservoir will work if it doesn't go through the hydropower. So there's a big need to keep it going through the hydropower, both for infrastructure as well as the power generation, which provides power to the western states, and Wyoming does receive quite a bit of power from Lake Powell. So those agreements have been agreed to by the Bureau, and they are being implemented as we speak. I'd stand for any questions on any of the basins that anybody would have for right now.
Senator Driscoll.
Mr. Chairman, Mr. Gephardt, the 500,000, that's federal water, correct? Not Wyoming water?
That is correct. Wyoming has no contracts in Flaming Gorge. In fact, Flaming Gorge has very little contracted use for that water anyhow. So it really is system water, but Wyoming does not have any contracted storage out of Flaming Gorge. Our biggest impact is probably to recreation. And we analyzed what these releases will do to the elevation, and we believe that it will lower it about 10 feet from where it is today. So by the time that 500,000 acre feet leaves, it impacts that by about 10 feet from where it was at the beginning of April, I believe.
Mr. Chairman, follow up. Go ahead. And I've had some calls. Is that going to affect some marinas pretty directly in Wyoming?
We don't believe that there's only one marina that in Wyoming, the Buckmore Marina, and we do not believe that the boat ramp will be dried, but they are making some plans for mitigation for their marina to keep moving it down as the reservoir drops. And also they're mitigating their potable water use. They pull their potable water use out of the lake. So they have plans in place to mitigate for that as well.
One more follow-up, Mr. And what has happened to our 200,000 plus acre foot that we're allocated? And I see we're going into regulation. And Wyoming has excess they've never used. Has that just been ignored to this point?
No, and I might bring Chris up to help with this, but so we are allotted what we beneficially use. So if we don't have beneficially use, we have no right to that water. So we have an allocation through the agreement with the upper basin. So we get 14% of the available water in any given year. And so if we don't use our 14%, then it becomes system water. Where we do benefit from that though, is it does go to Lake Powell and it does pass Lee's Ferry. Lee's Ferry is our trigger for the upper basin. And we have to have per the compact, our allocation under the compact is that on average, over 10 years, we have to have 75 million acre feet over Lee's Ferry over that 10-year period. So that averages to 7.5 million. So any water that we don't use, it can be picked up as system water, but anything that's not used and ends up in Powell helps the upper basin by it passing Lee's Ferry. And to date, we're at our average 88.5 million acre feet over the previous 10-year period. So,
Mr. Chairman, I hate to keep running, but so you're bulking us in with all the upper basin, yet it's Wyoming water, and I'm a little bit burr under my saddle on it. And so you telling me that we can have users have current priority dates to pick up that piece of the water up there? Because that's really what you're indicating to me is that's our water. So can someone show up and apply to get that water?
if the water is physically available, yes, we can still develop up to our allotted amount.
Mr. Chairman, and what's the process for someone to do that?
Apply for a water right.
Okay, thank you.
Any other questions on the river basins? Carry on, Director.
And then, Mr. Chairman, the last of my update was just to inform you guys know, but inform the commission of some of the interim topics that our office will be involved with. Select Water's priority number 2 is the pilot water conservation program. We discussed that yesterday with Select Water. Their number 3 priority is construction permitting for off-channel ponds. I believe that will be discussed in the August meeting. The number 4 priority was water rights issue associated with the development of lands within an irrigation district. That was discussed yesterday, as well as number 5, the groundwater interference with surface water and prior appropriation doctrine. And then number 6 is the review of the Wyoming Supreme Court case related to the conveyance of water across property. I believe we'll be discussing that this afternoon. And your number 7 priority is Reservoir 1 fill requirement. That'll be discussed this afternoon as well. Mr. Chairman, that was my update unless there are any other questions.
Thank you, Director. Any comments? Okay. Thank you for leading us into item 25, review of Supreme Court cases relating to the conveyance of water across property. Kaylee, could you change the screen so I can see more fully those participants that are zooming in? Thank you very much. We've got Senator Grew and Senator Hicks online with us. Senator Hicks, would you like to introduce us to this topic since it's one of particular importance to you?
Well, Mr. Chairman, I would love to. I would hope that it's in particular interest to the committee and the legislature. So, Mr. Chairman, so we've talked quite a bit about House Bill 2 and the disposition of those water rights in the case of subdivision or annexation of municipality, but that's one leg in the stool. And that deals with the actual physical water rights on the lands. And the other side of the leg of the stool that we haven't solved with this very same issue is what happens when you get subdivisions and there's a ditch that runs through there that was previously on one parcel and now it's got 10 different landowners. And so this document that the state engineers put together, it just talks about the legal access aspect relating to ditch rights and easements. Everybody has a copy of that. It's also on the webpage for the meeting materials. We looked at this a couple of years ago, and Abigail did some preliminary discussions, and I've had some discussions with a couple of water attorneys also. But we have the same issue. It's just now we're talking about conveyance systems where we have subdivision going on one hand, but yet now we've dealt with House Bill 2, got that passed. Good work. We're hearing. So the next part of that is we need to address the water when it goes across those lands that are subdivided. And I guess that's what I really want to take a look at here. And Mr. Chairman, I don't know if we want to walk all the way through this memo of the state engineer's office, but if we could call that up, there's 3 specific provisions in this document that I think are very pertinent to this discussion what we had with House Bill 2 and the change of the statutes relating to that associated with subdivision. Mr. Chairman, there's another issue associated with these ditch easement rights that comes up periodically that we're starting to see as you get new absentee owners, new owners that are not familiar with irrigation moving into the state. And oftentimes they'll buy a piece of ground and it'll have a ditch across it. And the automatic assumption is well, it's their property, they own that ditch and they can do whatever they want with it. And yet the water right holder oftentimes may want to go do some maintenance on that ditch, or he may want to participate in different farm bill programs through the NRCS to do some ditch lining, piping, any improvements to that ditch, and it becomes a legal battle. And the way it's currently structured, we have a number of AG opinions associated with that, and at least one Supreme Court ruling associated with the maintenance and access and who owns it and what the new landowner can do or can't do with the ditch. The problem that we run into as we get subdivisions and new landowners is right now, the only remedy is to go to court. And yet we have a preponderance of legal opinions from the Attorney General's office and Supreme Court rulings that lays out what those remedies are. And so what I would like to do is maybe look at codifying in statutes at least 3 provisions within this document that addresses those issues. So, Mr. Chairman, I don't know if the members have that document in front of them, but I would, if they do, or if we can pull that up on the screen, I would like to take it to 3 sections.
Senator
Okay.
Hicks,
Yep.
we have a hard copy in front of us, and we've all read the document prior to coming to the meeting. So if you want to focus on specifics, that's what we'd like you to do.
Yeah, so the one that I'd like us to focus on is question number 4. And this gets to the case where you have a new landowner comes in, or any landowner that buys a new piece of ground and there's a ditch across it, but there's no recorded easement on that ditch. And so the Wyoming Supreme Court in 1956 referred to the case of Haynes and Gallus, went in there and says, an easement may be created by prescription, or more properly speaking, under the modern doctrine of presumption. And it goes on. I'm not going to read that to everybody here, but what I would like to do is direct staff, Mr. Chairman, to go in there and look and see how we would codify this in statutes. And it has a limitation in there, 10 years, but basically take that opinion and create a statutory reference. And it would be a reference based on the presumption that there's an easement on that ground. And so that would be one aspect. And that's the Supreme Court ruling that I referenced earlier that we may want to try to codify. Mr. Chairman, what I would like to do is take these three different bullet points out of this document, have staff draft up a statutory bill codifying this stuff. I'll work with staff, anybody else on the committee that would like to do that. And then we bring that back to the August meeting for the committee to review, take public comment on it at that point in time. After public comment, then send it down the road for further action at our November, December meeting. But at this point in time, Mr. Chairman, my preference would be go ahead and make that recommendation on this one. I can do that on all three of these as a global motion or just one at a time. How would you like to proceed, Mr. Chairman?
Let's, I'm with you on question number 4. That makes sense. Why don't you take us through the other two, if you would, Senator Hicks, and then we can also get some input from the state engineer's office, and then you can make a motion after we get the input.
Mr. Chairman, the next one is question number 7. It says, suppose I have acquired a ditch right by prescription, which is the one that we just talked about above, across neighboring properties. What do the statutes say about the width of my easement? That is, how many feet am I allowed along each ditch to go on my neighbor's property? This gets back to the maintenance issue when you have new owners on that, subdivisions and all that stuff. This just basically goes in, and there's if you go on down and you go to the next page on there, there's an attorney general's opinion out there that basically says you have a legal right to maintain that ditch to the extent that yeah, it's within the what I want to say, within your easement, but it has to be confined to the center line of the ditch, whatever is reasonable. In other words, obviously, let's say the Goshen Canal that carries 400-500 second foot of water is going to take quite a bit more of an easement to do the operation and maintenance than maybe a ditch that only carries 2 CFS. But what I'd like to do is have staff also look at that attorney general's opinion, and then look at this reference here and see if we can codify what that easement would look like based on the AG's opinion, and then this language in this document. The next one, Mr. Chairman, would be number 11. And again, this gets to, it is clear that my neighbor has a right to enter my property and maintain a ditch. What will happen if I try to stop him? Again, there's an AG's opinion. This would tie right in to number 7. But those are the 3 areas that I think gets back to what we tried to do with House Bill 2, was address the actual subdivision. How do you go through notifications and all that stuff? Now we're talking about how do you get the water across one of those. Now we're dealing with conveyance system, not the actual irrigated grounds, but it's the same issue, Mr. Chairman. So my recommendation, and Mr. Chairman, maybe we should have some discussion before I make a motion, but I would entertain any questions, and then maybe the state engineer would like to weigh in on this too.
I certainly would. Those make a lot of sense to me. Thanks, Senator. Director Gephardt, what are your thoughts on those 3 specific questions? So what Senator Hicks is doing is he's identifying Supreme Court decisions and suggested, why are we allowing the Supreme Court to make those decisions when we could codify them in statute, and then there's no more decisions left for the courts to determine. How do you feel about those 3 items?
Mr. Chairman, I think the last paragraph of the document kind of explains our role when we get into these ditch agreements, and we really don't have a role. This is a private property issue. We have no, we're not empowered at all to intervene with these. So this document was prepared because of that, to help give the answers that we kept getting. And we had to tell them that we can't be involved, but here's this. Do what you need to with this, because we're kind of out of that. So that's kind of where we stand with the state engineer's office.
I can appreciate that. In fact, throughout the entire document, you were coaching your ditch riders and those people in the field to try to help give advice, but to make sure that they were very clear that it wasn't binding and they're not attorneys.
That's correct.
All right, very good. Folks, Senator French.
Thank you, Mr. Chairman. Just one thing I'd mention in all of this. Say you have a parcel of land, a farm, and there's a ditch going across and it's subdivided, and now you have that ditch crosses 10 parcels. One issue that is out there that's a problem is maybe they're 5-acre lots. They want to fence it for the horse. Well, suddenly if they want to do maintenance on the ditch, there's no gates. They don't put gates in. So to try to get through somebody's yard with a track hoe or something across their lawn to get down there to do a little bit and then back out the next person's, versus if all those lots on each side had a gate over that buried lateral or that ditch, then they could open gates. You know, those fences block them in a sense, and everybody raises Cain if they take the track hoe across the fence to, just bulldoze right through the fence. So that's something everybody keep in mind, if those lots over those ditches, buried laterals and stuff had a gate on each side, then anybody going in there to repair or maintain a buried lateral, a ditch or whatever, they could just simply open the gate and do their thing, and not destroy a fence. But you have all these fences there and you can't access it. Makes it really difficult. So that's just something for people to keep in mind.
Senator Driscoll.
11 and 18 deal specifically with that. That basically says they can't impede you to do it. So if they're smart, they'll put the gate in. Otherwise, you've got the right. Their fence impedes you, and you can go in and cut the fence and do what you need. It's pretty clear in here. Thank you, Mr. Chairman.
Senator French.
Just to follow up, I would agree, but soon as you go and cut 10 fences, cut the wire on 10 fences, then you're in court. You got a lawyer up to defend yourself. Hey, I have the right to access that, and I guarantee you they'll put you in court, and then suddenly you're like, well, I have the right to do that, and you've spent $10,000 or whatever on attorney's fees to point that out, but you're correct.
Mr. Chairman,
Senator Grew.
now this is Senator Hicks.
They look a lot alike.
I know,
Yeah.
but Senator Grew had his hand up first, so we're going to go with Senator Grew.
Okay, I didn't see his hand, Mr. Chairman.
Actually, Senator Hicks, I'm going to ask a question for you through the chair, of course. So, Mr. Chairman, my question is on, and actually Senator Hicks kind of brought it up, on 11, what would be your take on that? If the ditch was holding 7 water rights and a whole bunch of surface acre feet of water, and I just have one little bit, but I want to do something, how do you parse that out to say how much easement would I be entitled to? Because I'd have to do work on that whole ditch. How would you see that playing out?
Well, that's kind of a separate question, Mr. Chairman, because if you're a member of a ditch, you'd have a ditch company. And so the ditch company typically is responsible for maintaining the ditch, not the individual for his 1/10 of a percentage of the ditch. And so that's the normal arrangement that I'm aware of. I don't know of any ditch company that partitions out a percentage of the ownership based on that. Does that answer your question?
Yeah, Mr. Chairman, if I can follow up, yes, it does. And I understand the others, I understand, and I understand all three of them, where you're going, and I don't have a problem with bill drafts and take a look at it and get some testimony. I was just I didn't understand that part, but now that you say that, that makes perfect sense. Thank you.
Senator Hicks, your thought?
Mr. Chairman, I think both the state engineer and then the conversation with Senator French and Driscoll put a fine point on this. Is ultimately the state engineer has no jurisdiction whatsoever. So the only remedy is a civil action is you end up in court, and it's exactly what Senator French just talked about, is because we have no statutory guidance here, and there's only either Attorney General's opinion or Supreme Court cases. The only remedy is to let the courts sort it out. And so what I'm trying to do is say, maybe the legislature should probably take a look at this. Not that I have anybody that practices in the legal profession. I just don't like landowners suing each other all the time for something when it's obvious what the outcome of the case is going to be anyway. That it's incumbent upon us to try to simplify this for everybody involved versus creating economic opportunity for one industry sector in the state of Wyoming.
Which shall remain nameless. Senator Hicks, there seems to be a general consensus that we're interested in pursuing these, so why don't you make a motion?
So, Mr. Chairman, I would move that we authorize staff to, and I would encourage staff to work with the state engineer's office to tap into any expertise they have, or even the Attorney General's office to try to craft a statute addressing these three issues outlined in the memo, number bullet 4, 7, and 11, and have a draft available before our next meeting, Mr. Chairman. That would be the motion.
Excellent. Thank you very much. It's been moved and seconded that we begin the process of drafting legislation that would address, make sure I get the terminology right, related to conveyance of water across properties and looking specifically at legal aspects related to ditch rights and easements prepared by the Board of Control in 2009. Any further discussion on the motion? Seeing none, we'll vote. All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed, say no. Motion passes. Abigail, are you clear on your instructions? Perfect. Thanks. Senator Hicks, that is a good idea. It'll be fun to see how that develops and what the public thinks about it. All right, we're ready now to move on to item 26, Reservoir One Fill Requirement. This request for your information came out of Management Council. A member of our body was interested in this, and the Management Council requested we add it to our interim topics. And so Director Gephardt is here, and we also have a handout, a memorandum from Abigail on this topic. So let's start with Abigail. Would you just summarize your memorandum to us, Abigail, and tell us what is the doctrine around Reservoir One Fill?
Mr. Chairman, in looking at this, there was cases brought before the Board of Control, which resulted in Supreme Court case law. And then following that case law, the Board of Control actually put it into its rules and regulations, what is basically now the current one fill requirement, which you'll see quoted at the end there. But sort of the foundation of the court's rationale was that under the prior appropriation doctrine, you really can only use your water right once in priority. So I think that would be the short of it.
Thank you. Director Gephardt, would you expound on that? What's the actual situation being used on the ground for filling reservoirs once a year?
So, Mr. Chairman, I'll try, and I may have to phone a friend in Chris to help me with this. But the one fill, it is in rule, and the concept is that we have to quantify what the water right is. And with the one fill rule, we're quantifying that water right by the bucket that is the reservoir. So you get a water right to quantify that so that you don't, so start over a little bit. So if we have a reservoir and we don't have a quantified amount that goes to satisfy that reservoir, then in practice, that would make that reservoir water right be able to call any junior right until that's satisfied. So
Director, I've got to have you help me understand something. So if there is no storage water rights, so we're not talking about big reservoirs. We're talking about smaller on-farm reservoirs, probably. Is that what you're saying? When you said there is no storage water right in these kinds of reservoirs, what?
no, if there is a storage water right,
Okay,
And it-
all right.
if it's not quantified, if that storage right were not quantified, then when do we stop filling the reservoir? What's the limit of that water right? So that would mean then essentially that any junior user, when can they call off a reservoir? If we don't limit it to a quantified amount, when would that stop? When would the junior right have priority?
You don't mind if we interrupt you with what we were trying to
Mr. Chairman,
understand? Go ahead,
I'll just
Senator.
go slow and then I'll comment afterwards because it delves back to this exact case and exactly what you're talking about. The understanding you're doing, I get it. This cup, so if I've got, this is my reservoir, I've got the right to fill it once a year, assuming the water's there. But I don't have a right to fill it a second time because of its potential effect. And I go back to prior appropriation doctrine. I'm who brought this here. And it's all based on affected parties. That's our junior and senior water rights, is if I've got a senior right that lays at the very bottom of the stream and a junior right's at the top, he may have to watch water flow by his place for me to have my right filled. That's the way that prior appropriation works, the way I understand it. In a case of a reservoir, there's no harm being done to any appropriator, senior or junior, assuming there's no call. So what we have in a lot of areas of Wyoming is we get a big rainstorm in the middle of the summer. And what we do is we export a huge amount of water into adjoining states because nobody's drawing. Their soils are all saturated, everything's full, and we bypass that water. They make you leave your head gate open on your reservoir and it flows right through, and it flows through the neighbors, and it flows through the junior appropriators, and flows through the senior appropriators, and it hits another state. And my deal is I totally understand you can only fill your cup once. But I certainly do not understand, in reading the case, which they didn't print the case and gave it to us, but I pulled it up and read it. I certainly don't see where there's any impact on this case if in fact that you have to open your head gates and let the flow out if anyone requires the water, anyone, any water right. So if, let's say my cup's full, it's empty. I used it up, it's a dry year, we get 6 inches of rain, everybody's saturated. What's the harm of my head gate being shut and fill a supplemental supply that is not part of that right, but it's still there, it's storage. And it's available to be used instead of flowing to another state. And I think we have a hole in our law. This prior to this decision, which is really interesting, it's almost an irrigation district against itself to some degree. Prior to this, for over 100 years, they were allowed to fill reservoirs repeatedly in the state of Wyoming with no severe problems. I don't see a lot of other cases out there. I don't see a lot floating, and I question what we've done. It's under rule, it's not under law, and it really isn't. When you read the summation of the court case and you look at it, it really doesn't create a one fill rule. It creates a damage to a junior right. And so to me, I think if we codify, if we went back and created a section of the statutes, or that you did it by rules, it says anytime someone makes a call, which is what we do right now, if someone says, hey, I don't want to do it, it's as simple as telling your ditch riders, hey, the guys can't close they got to open up and let the stream flow through. If there's 2 second feet above, they're going to have to pass through 2 second feet regardless what's in the dam.
Thank you, Senator
What's the
Driscoll.
damage to that? Thank you, Mr. Chairman.
That helped us quantify the challenge.
Yeah,
We should
that's why
let
I
you
was
go
trying
first
to
so we could identify the challenge. So let's go back to the state engineer's office and please continue in helping us understand what the current policy is.
Okay, thank you, Mr. Chairman, and Senator Driscoll, thank you. In practice, we do interpret that law or the rule loosely. In fact, in our Wyoming Hydrographer and Commissioner Manual, this is dated 2015. It is possible, I'll quote it, it is possible and allowable for a reservoir to accrue more than its one fill in 1 year if water is available and not needed by any other appropriator. See Free River Condition discussion on page 15. So by practice, we will allow, if there is no injury to another user, we will allow more than one fill.
Mr. Chairman,
Go ahead.
is that codified or is that in your rules? Because they certainly don't do that in the county I live in. My head gates are told to be left open. When we empty our reservoir, we're told to leave it open. And I've been told that directly. This is a personal deal. You can call it a conflict if you want, but for us, we've been told when it's open, it's done. And I don't have the handbook. I need to get a copy of it from you, but we vociferously complained. We've gone for about 100 years out of that reservoir, refilling it. And the last number of years, it sits high and dry all summer. It's a fishery for the state of Wyoming that they've stocked repeatedly. And it sits dry now for the last number of years. It sits empty. And it's not just me, it's happening in other places. I see some heads nodding. So I appreciate your comments, and maybe that we're just got an individual area that's not getting followed out of your manual.
Yeah, and Mr. Chairman, Senator Driscoll, I'm not aware of your particular case, but I think it's certainly something we could look at, and I would encourage Chris to jump in here too. He and I have had some conversations, and I think he can bring.
Chris, before we go to you, I'm curious, are other ranchers and farmers, do you have reservoir situations? Have you been told to only fill once?
So,
Representative Eklund.
Mr. Chairman, I've heard complaints on Crow Creek. There's a reservoir just not far from Cheyenne. And it's the opposite complaint. It continually refills. And if it does, then the creek water down Crow Creek, and it's a bunch of irrigation below it, those wells can't irrigate if the creek doesn't flow at some point in time. They run out of water in their aquifers. So that's kind of an opposite problem, and I'm not sure.
Well,
I think you're aware of that.
That's
that happens.
interesting, though. Thank you. Representative Nyman.
Thank you, Mr. Chairman. Yeah, this has been very illuminating to me as well, because I guess I should have done more due diligence as I was looking into this, because I actually looked at trying to put in a reservoir on a tributary to the Belfouche River. But my major hangup was the one fill rule, and the fact that I would put that much, infrastructure in, and it could only fill once, and it would be filled almost immediately. But then as it diminishes over the course of summer, I couldn't refill. And the whole thought was, as an effort to try to extend my water right on there and be able to utilize it when things get low through the course of later on in the summer, that I could release from that reservoir and stuff through that time. So I guess I did not realize that you guys have that on the books in there and that would be willing to, but I appreciate Senator Driscoll's question. Is that just a rule that you guys just, I mean, Director Gephardt, when you leave, can that disappear? Or is that something that is codified in statute or anything that would create a long-term ability to have that opportunity? Because it definitely is an issue where we're at up in our part of the country.
Hold that thought. Any other ranchers or farmers? I've got a room full of experts on the subject. I'm anxious to hear your input. Nothing? Okay. All right. Let's go back to Chris. Would you like to share some thoughts on this?
Thank you, Mr. Chairman. Chris Brown, supervise the water section of the Wyoming Attorney General's office, and I'm just hoping to helpfully put a little more context in this and kind of some of our discussions yesterday. Many of these questions are really dictated by the local factual circumstances. You can get into a whole bunch of different scenarios, but hopefully I can relay a couple of factual instances that might help us think about some of the issues. One being on Crow Creek, which has certainly been a perplexing problem for a number of years that hopefully is resolved. But let me talk about the one fill rule generally, and that was a rule that has been announced by the Wyoming Supreme Court. Of course, it was following a decision that was made by the Board of Control, which was an implementation of the one fill. So before the Board of Control actually put it in its rules, this is something that stems from the way that reservoirs are permitted through our process to begin with. It's permitted to a capacity. And dealing with, you only get the amount of water that you're permitted to have in Wyoming, be it direct flow, be it groundwater, be it storage right. That is the extent of your right in the Board of Control's interpretation. You have the opportunity to fill it to the capacity of that reservoir. And that's largely to avoid speculation, allow folks to grow into a water right that they might not have a reasonable use for, the anti-speculation doctrine under the doctrine of appropriation. And also to assure that we're not harming junior appropriators that come to this system after whatever that facility is. You're limited to what it is you need at that time for beneficial use. You're not allowed to expand it into the future. The idea about the opportunity for a second fill on Free River has been around just as long. And the notion of the one fill is you have a legal entitlement under your water right, under that priority date, to fill one time. But if the stream, just like direct flow rights, if the stream is not under regulation, you are welcome to take whatever you can beneficially use. And under the reservoir scenario, you can fill. If it's Free River, there's no regulation going on. And this could be regulation, intrastate regulation for the benefit of senior Wyoming rights, or we see it happen with regard to regulation under an interstate compact for the benefit of the downstream state. It happens under the Belle-Fourche Compact, I believe. Happens under other compacts that we have as well. But just like direct flow rights, you're not limited to, under a direct flow right, to a 1 CFS per 70 or even 2 CFS per 70 if the river is not under regulation. If it's not under regulation, it's a senior right has not made a call. Any appropriator is entitled to take just as much water as they can take, the only limit being beneficial use. You can't take more than you can beneficially use, or stated another way, you can't take water and waste it. But if you have the beneficial use under your right, it has to be used where you have the right to use it, but if you have the ability to use more water than your right in a Free River condition, you can. You're not limited to 1 CFS, you're not limited to 2 CFS. You can take just as much water as you need as long as you can beneficially use it, and that is actually in statute. And like I said, the one fill rule, and it's applied all across the state. If we're in Free River condition, a reservoir can fill more than once. And just think about it as the reservoir is already filled once during the water year, starting October 1st. It filled during the water year. We've drained it some for some use. We're still not in regulation. It's essentially the junior right on the stream. It's not going to hurt anybody else, so it can just fill again. And this was the situation that occurred on Crow Creek for many, many years. And there's a very interesting reason why that happened. And let me talk about the Crow Creek example just briefly. And there's a couple of fairly good-sized reservoirs on Crow Creek that are just downstream from the city of Cheyenne, and there's no other significant surface water rights below those reservoirs on Crow Creek. A long time ago, all those rights down there all went to the ground, right? And all the major irrigation rights down there all pumped from the ground. And the problem with that is there was never a call. There wasn't a right downstream from those reservoirs to make a call, so we're always in Free River condition. And so there wasn't and it's the second fill always in effect. Because there wasn't a call, there wasn't a junior appropriator putting a call on the stream, those reservoirs were continued to fill. Not long ago, some of those groundwater appropriators says, we need this stream flow in order to recharge the aquifers that we can use our groundwater wells, who are senior to the second fill, right? And so we need to be able to make that call. And so they put in an application to the state engineer at the time in order to do a groundwater recharge project. And in looking at that scenario, and this is one of the statutes that we took a look at yesterday, it's 41.3.916, and this is the interconnectedness statute. The state engineer at the time declared that it was a single source of supply because the waters were so interconnected that they constituted a single source of supply, and so that the water rights that drew from that supply would be regulated in a single schedule of priorities. Essentially what it allowed was for the groundwater users downstream on Crow Creek to put a call on the creek so those reservoirs couldn't get a second fill. So that is the status of things now. And just to put a finer point, and remember, and I can fully appreciate the individual circumstances, the smaller on-farm reservoirs and the potential complexity of getting water from here and there inside some of those systems. But remember the potential impact that this could have on some of the bigger reservoirs that we have in the state. I can tell you that the Bureau of Reclamation in the past has attempted to actually file formally for a second fill, and it was denied by the state engineer. This is one of the major issues that we had in the litigation with Montana. Brandon just said, we just got done responding to a call from the state of Montana to fill Tongue River Reservoir. When we were in the middle of that litigation, Montana claimed that it did not follow the one fill rule, even though it has a Montana Supreme Court case that says we absolutely, they had a case before Wyoming had a case that said we follow the one fill rule. But Montana argued vigorously that no, we don't. We don't follow our own Supreme Court in this regard. And so it argued in that case that it had the right under the Tongue River Reservoir to fill all the unappropriated water that existed at the time of that reservoir, which is a priority date of 1937. And if they would have won that argument, that would have essentially precluded any post-1950 storage in the state of Wyoming. They didn't get away with the full appropriation. They next argued that they had a right to fill it a time and a half, 127,000 acre feet for an 80,000 acre foot reservoir, and argued that they had historically operated in that way, and therefore they had a right to fill it to 127,000 acre feet. We very strongly opposed that and very strongly asserted the one fill rule. And today, the United States Supreme Court, they recognize they only have a right to one fill as against the junior appropriators in Wyoming. It's Free River, they can fill it again, but they can't call on a junior appropriator to fill it again. And that's the rule.
Excellent. That helps a lot.
Mr. Chairman,
Thank you.
Senator
Mr.
Driscoll?
Yeah, I appreciate very much you've done. Your office isn't following your own rules, clearly. I mean, or somebody's not. But regardless, there's a difference between a right and a second fill. It doesn't create any right. I got the right to fill it the first time. The second one has no right to do that other than if you're in Free River status, which I don't know if Free River's in statute or not. I'm not up on the statutes good enough. But I can tell you, in fact, on the ground, they're not allowing us any type of fill. And for your end, back to the end of it, I'm pretty familiar with Belle Fourche River Compact. And there's never been a call on the Belle Fourche River, if there has been once that I know of. And it's been a point of rub because we go into compliance with the state of Wyoming regulators right now without the river being in a call. That's happened multiple times. They've asked us to shut down. And, you know, my knowledge is this, and I know it happens down in Representative Nyman's country, is we operate under our own priority system. As long as there's not a call on the river, it's our right to use that water as long as we got existing rights. If they want to enforce a call, they need to make a call on the river. I realize that complicates your guys' life, but they need to run by the rules. And that's really part of what you're seeing is frustration up and down the river. We had it happen last year. They shut down, they dried up the place in Cook County last year without a call being on the river. Representative, Mr. Chairman, but to me, I tend to go back to the Free River and put it in statute. I don't care about the feds either. If the river's in free flow, that water's going downstream. And I can tell you for South Dakota, at least against us, Burek in South Dakota bypasses that water when we hit the big storms because they're full of silt. They dump them out in the Belle Fourche River and they go on down. It's been one of the things that's drove me insane is Ormond won't be full and they'll be bypassing water because they don't want silt in Ormond. And yet I can't catch it in my dam. I'm sitting there with a head gate open. And I think that your sense of frustration is for real.
Thank you. Senator Hicks, did you have a comment?
Yeah, Mr. Chairman, I think this is laid out. This discussion is really what we need is a clear statutory scheme. I think Chris laid part of it out. What is and what isn't in statute? How does the statute then, how does the rule then follow the statute and the guidance? And then I think Director Gephardt talked about under the Free River scenario that it's loosely administered or interpreted under the one fill. What's apparent to me is all these working parts out there and nobody understands them. And so what I would ask is if the agencies could put that schematic and the statutory rule, interpretation of the rule, and how those court rulings play into this whole scheme of the Free River, the second fill, the what statutory thing on and I don't want to get into the interference stuff. We're just talking about free or second fills. I think it would be helpful, very helpful for particularly me to understand how those things interplay and which one governs. And if we could get that at our next meeting, that would be helpful to understand this. I take this just a little bit a different tract on this. I think we're missing some opportunities in the state of Wyoming based on our own one fill rule. And I think it's going to be particularly important as we continue to move forward on the Colorado and we have conversations of how Fontenelle could play into here. And I think Chris really articulated well the fact that you have to have that beneficial use tied to that second fill. And I'm not so sure that we have all the enumerated beneficial uses that we would want to in the Colorado River Basin to fully exercise the ability of a second fill. And so I'll just tell you, I think we need to look at something in context of this second fill concept, look at compact compliance and drought contingency moving forward. And specifically as it gets to Senator Driscoll's comment that in some cases, we're just letting this water run downstream when we should be capturing it as long as there's no impact to any existing water user on the system. And we may be doing that in practice, but I wonder when it comes to the legal aspects of a curtailment or a regulatory call or compact call, how our own one fill rule may be limiting us on the ability to meet compact compliance. But it's just my thought, Mr. Chairman. So I would ask Director Gephardt and Chris if it's feasible to put that kind of statutory rule framework flow chart together for us for the next meeting.
Director Gephardt.
Mr. Chairman, we will effort that.
So let me make sure I'm really clear on this. So there's been understanding in the field that the one fill rule is it. That's all there is. you read to us out of your field manual that says, if there's no call on the river and there's ample water and no one's going to be damaged, let people fill a reservoir twice. Is that correct? So that's your internal policy. There seems to be a discrepancy of whether or not some field people are adhering to that. So what Senator Hicks has suggested is, on a bigger scope of things, is our policy, loose or not loose, damaging the ability for the state of Wyoming to retain every drop of water that we can justify along the way. I think it's worth investigating. So we'd appreciate your efforts in coaching us and bringing back some information. We certainly wouldn't want to codify something that is going to be damaging to us or that's going to cause unintended consequences. That would be really unwise on our part. But if it's pretty straightforward and you can recommend some things to us, I think it's certainly worth looking at.
Mr. Chairman, I may have a question, but what I understood, the request to be is our understanding of how we use statute, the rule, and in practice, and how all of that ties together and present that. Is that what I understood?
So, Mr. Chairman, that would be correct. So I would start with the statutory reference that talks about free river. So when is it a free river? What is that statutory definition? If there is a statute. And then tear that down. Does that make sense, State Engineer Gephardt?
Yes.
And so once you present that to us in August, we can determine if there's legislation that needs to be drafted up. And Chris, we would really appreciate your assistance if there is legislation to be drafted. We'd sure like to have your insight into making sure it's written in a way that's going to protect us all the way around so that we're not doing something that would not be wise. Go ahead.
Mr. Chairman, I'll be happy to work for the state engineer upon his request.
Thank you. That's your job, huh?
Mr. Chairman.
Senator Driscoll.
One more question, and this goes back to BUREC, because I echo the chairman's good thoughts as far as we certainly don't want to do something that causes harm. I'm more along the line of Commissioner Bishop in the old days of how does Wyoming keep every drop of water in Wyoming that belongs to Wyoming. And so could we possibly get around the BUREC deal by putting a deal that says back on the Free River that it only applies to 1,000 acre foot or less, or 2,000 or less, or 3, because these BUREC facilities are huge. All of them are big. They're 100,000 acre foot plus. So what we're really hitting on most of these are smaller type facilities that are on drainage that probably should have been bigger reservoirs, in all honesty. They probably should have had a lot bigger right on them, but cost too much money to do it. I can tell you ours is certainly that way. The Water Development did a study on it. Ours supports a 4,000 acre foot reservoir, yet it has a 100 acre foot reservoir on it. They were shocked that it stayed in. So I think there's some leeway in there to try to do that. My goal is, like I said, how do we keep every beneficial drop of water in Wyoming that we legally can do? I don't want to violate compacts, and I certainly don't want to violate anybody in the prior appropriation doctrine that has a right. Is if someone downstream needs water and they have a right that's in priority, they certainly should be able to do it. I mean, that's common sense. But it's also common sense that if you can impound some water that can be used to put beneficial use in the state rather than crossing the state line, that seems to make an incredible amount of sense as well to me. And, you know, and these are tough. In reality, you rarely end up draining them. I can tell you once again on the streams that I know, and multiples of them, there's all kinds of illegal impoundments on them that you could legally drain out, but it's be a cause of some kind of death in the county to get it done. To force you guys to drain them, because they're kind of interesting. So, I really believe anywhere that you can impound water and hold it, that doesn't have a detrimental effect either on a downstream user or someone else, that we really should be looking at that. That ought to be the goal of this entire body in the state.
Okay, I think we're ready for a motion. Who would like to make that?
I'd make a motion that we, Mr. Chairman, I would move that we have Director Gephardt, and with the help of the AG's office, give us a flow chart of how the one fill rule is there, what part of it's in statute, what part of it's by rules, and what part of it is non-rules and manuals, in a cohesive flow chart that we can see. Give us a definition of free river, either in statute or from court decisions. And then I'd also like to see you bring us, rather than summaries, actual copies of court cases that have direct impact on the one fill rule.
Ooh,
That
that was
long
an
motion,
awful
but
long
I
motion.
think you understand.
Fortunately,
maybe.
Abigail's got it on video, so she can play it over real slow and get it all down. Do I have a second to the motion?
Second.
Okay, it's been moved and seconded. Abigail, do you have a comment before we discuss this?
As long as the mic was on, I could replay it. And
It
I'm
was
not,
on.
it was good.
It was on. Any discussion? This makes sense. Appreciate you bringing it to the table. All right, all those in favor of the motion, please indicate by saying aye.
Aye.
Those opposed? Motion carries. I got to go back to my agenda. Are we through or not? Wow. Does anyone else have any comments? Director Gephardt, Director Mead, anything else you have for us? Wonderful. I look
Mr.
forward to
Chairman?
this in August in Star Valley. Senator Hicks, did you have a comment?
Yeah, I would just like to thank you. You run a very fine meeting, Mr. Chairman, and I appreciate your getting us prepared for this meeting and putting together the agenda. And I was looking forward to coming over to your neck of the woods in August, but unfortunately, I've got another commitment that I have to keep with the caribou up in Alaska. And so as much as I'd like to see you in August, Mr. Chairman, I will have to ask for your permission to be excused from that meeting.
That is such a lame excuse, I'm here to tell you. Seriously.
Permission denied.
Judge Gephardt, did you have a comment?
I do, Mr. Chairman. Our Board of Control, our August Board of Control coincides with the Select Water meeting in August. I think we can make arrangements to attend, but it'll have to be virtually, because we will be in Casper for the Board of Control.
Do you have some staff that you could send for just miscellaneous questions? And we can Zoom you in during critical times. Do you have water rights staff you can send?
We can have people attend, yes.
Appreciate that.
Mr. Chairman, maybe by that time you'll have a deputy state engineer and he can send him into the wolf pen.
That would be good. Love that. All right.